Hello everyone, welcome to Research Academy. This is the founder of Research. Let's start with the legal talk. I know it's quite, after around 20-25 days, just starting with the legal talk series. But nonetheless, there are certain changes that we have made to this series. I want your suggestions. So please comment below what are the things that have been added and compare the things that we used to do now what we are doing. Okay. So you will get to understand what we are trying to do with this series. So let's start with the legal talk. In the first legal talk, we are going to talk about the section 313 of the CrPC. Now, 313 of the CrPC basically provides an opportunity to the accused to offer an explanation after the prosecution case or the evidence is produced. Now, basically, in this case, क्या हुआ था कि the accused has been charged under section 366A and the 506 of the Indian Penal Code for enticing a minor for indulging into the illicit relationship. Now, उसके बाद क्या हुआ? Trial process, everything was going great, except the one particular procedure that was not taken care of the trial court. That is section 313, the right to offer an explanation to the accused, and that's why the accused came to the Supreme Court via High Court that this right has been infringed. And then Supreme Court looked into the matter, and Supreme Court says actually this right has been infringed, and this is one of the valuable right must be provided to the accused to offer an explanation. So that's why this case must be set aside, because the prosecution has failed to prove it's guilty beyond reasonable doubt. In the second legal talk, we are going to talk about the UGC guidelines. There are a lot of petitions that have been filed against these UGC guidelines that have been issued by the UGC in the month of July, and also Ministry of Home Affairs confirmed that guideline, but petitions were filed by the students, other persons relation to that, and it's very difficult that from the student perspective they are saying that their fundamental rights are getting breached, Article 21 is getting breached, whereas the Supreme Court also asked the UGC to come up with a reply, and they said they're quite adamant they're not going to change this, that they're going to conduct the final year exam by 30 September 2020 because they want to protect the academic future of the students. So in both the case, let's see if Supreme Court will definitely intervene and will give the verdict. We are going to definitely let you know. In the next legal talk, we are going to talk about the Vikas Dubey encounter case. In that, inquiry commission has been set up. The Supreme Court में petition file किया गया था कि वो reconstitute किया जाए inquiry commission को. It was previously that inquiry commission was headed by the Justice P.S. Chauhan. Now the Supreme Court dismissed the petition. That पुराने वाला inquiry commission, not पुराने वाला, the inquiry commission that was set up earlier, that is going to continue the work. Now, in the next legal talk of the Supreme Court news, I'm going to talk about the two words, the socialist and the secular. Both words were incorporated into the Constitution by 42nd Amendment. That we all know it. Okay. But here the petition have been filed. Both the terms must be scrapped from the Constitution because they impress some kind of ideologies onto the citizens. That's why it must be scrapped, because we have our fundamental right like Article 25, Article 19. We have the right to profess the religion, we have the freedom of speech and expression, and that's why those ideologies must be scrapped, and hence the secular and the socialist, this particular two term must be scrapped, because it also going against the principles of the democracy. Okay. So what do you think? Is it going against the principles of the democracy or not? Kindly comment below. Now let's coming on to the High Court news. What we have today in the High Court news, we're going to talk about the Arogya Setu app. In the District Court of the Delhi, there is strict guidelines that have been issued that you have to have the Arogya Setu app installed in your mobile phone to enter into any of the District Court of Delhi. But that particular guideline is really harsh on some of the people, and that's why the petition has been filed in the Delhi High Court asking their intervention, that this particular guideline is really harsh, not fair in nature, because there are a lot of people who enter into the premises of District Court of Delhi. Basically, they are not economically well off, and they don't have the mobile phone, how can they have Arogya Setu app to be installed on the phone? I mean, that's impossible. You are asking too much from the people. So that's why that guidelines should be taken care of and must be set aside. Now, in the next High Court news, we are going to talk about the Karnataka Epidemic Disease Ordinance 2020 news. It's related that the recent ordinance has been promulgated by the Karnataka, and Center few months back, Center has also promulgated the Epidemic Disease Ordinance 2020. Now, here, the petition has been filed in Karnataka High Court asking the state ordinance to be set aside solely because there are some in conflict with the punishment in state ordinance and center ordinance. So that's why it must be scrapped, the state ordinance. But Karnataka High Court said to the petitioners, you need to understand first whether the center ordinance is going to apply in Karnataka or not. That is the first and foremost question. So this question comes later, the difference in the punishment and the offense and all those things. So we have to set aside this petition. So these are the High Court news and Supreme Court news. Let's move into the current legal affairs that we have for today. In the current legal affairs, we will see that All India Bar exam has been postponed. It was scheduled on 16th August. It has been postponed. IELTS has been postponed yesterday. The next date hasn't been notified for All India Bar exam and IELTS 2. Next is CLAT. Who knows, that might get postponed too. Will notify regarding that. Okay. And the next legal talk, we are going to talk about the national education policy. I hope you have already watched that national education policy videos all over the YouTube. There are a lot of YouTube creators have already made the video on national education policy. It's such a fulfilling to know that these are the things that are going to be done in the future. I hope the execution is properly done, so that we can expect a really bright future for India. What do you think? Kindly comment below. What do you think about this national education policy? And now, in the next legal talk, we are going to talk about the Supreme Court didn't entertain into the CLAT goes online, because CLAT has shifted from offline to online, and also CLAT has given the reason regarding that why they have shifted. Due to the COVID-19, a lot of paperwork was needed, a lot of manpower was needed, and that's why they shifted from offline to online. So, and Supreme Court was rightly didn't was right about that, didn't enter into that particular application. So these are the legal talk that we have for today. Thank you. See you soon. And bye-bye. If you like the video, give it a thumbs up, and don't forget to subscribe our channel, because we come up with legal talk every day that will help you in your competitive exams. Thank you.